Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 17. It's case number 17 in the list of leading cases for the AOR examinations, and the case is titled as P. Ramchandra Rao versus State of Karnataka. Now, this case is basically dealing with right to speedy trial, and this case is looking at the judgment of the Supreme Court given in the earlier cases, which are a Common Cause versus Union of India 1996 and Rajdev Sharma versus State of Bihar. Now, what is happening in these two cases? Okay, what is happening in Common Cause versus Union of India and Rajdev Sharma versus State of Bihar? Basically, the Supreme Court had issued direction with respect to fixation of outer time limits for trial of for conclusion of certain for trial and for conclusion of certain criminal proceedings. Okay, now the question before the court, the question for consideration before the court herein is that if the decisions in Common Cause and Rajdev Sharma are applied, which are prescribing the time limit for completion of criminal trials, are they constitutionally valid or are they binding? Okay, now in those cases, it was also held that there can be automatic acquittal solely basis on the delay in trial because it violates the principle of justice and rule of law, and whether the right to speedy trial as guaranteed under Article 21, also in the case of Husainera Khatun versus State of Bihar, does it really requires a rigid time frame or a case by case approach? Okay. So can we, apply a rigid outer timeline to all the cases, or it depends on the cases in front of in front of the bench? Okay, so the question for consideration, main moot question for consideration therein was whether a court in its zeal to protect the right to speedy trial of an accused can devise and almost enact such bar of limitation through the legislature, though the legislature and the statute have not chosen to do so. Now, in this case, it is a 7 judges bench judgment because the earlier judgments were 5 judges bench, and the court herein is also looking at the viewpoint taken in the case of ARAntulayVsRSNayak versus RS Nayak, and court herein is saying that time limit cannot be prescribed judicially for the criminal trials. Okay, so this is for legislature to legislate upon, this is for legislature to look upon, and you cannot legislate upon the powers, upon the subjects that are in the power of the legislature. Okay, now the court herein is saying that laying down outer time limits for the conclusion of trial is an essential legislative function, and if courts are doing so, it will fall in the purview of impermissible legislation, it will fall in the purview of impermissible legislation. And right to speedy trial is not a mechanical formula. Okay, it is not very much mechanical that you can fit it in one box and you can say that to every criminal trial this kind of time limits are going to apply. Okay, so court herein is saying that prescribing periods of limitation at the end of which the trial court would be obliged to terminate the proceeding and necessarily acquit or discharge the accused, and further making such directions applicable to all the cases in present and for the future, amounts to legislation which cannot be done by judicial directives, and it is not within the arena of judicial lawmaking powers available to constitutional court. However, when we do a liberal construction of Article 32, Article 21, Article 141 and 142, it can be interpreted. Court can declare the law. They can interpret the law. They can remove the lacuna and fill the gaps. Okay, we can by way of delegated legislation or by way of exercising the legislative powers, gaps can be filled. Okay, but you cannot entrench upon in the field of legislation properly, which is meant for the legislature to, legislate upon. That is one thing the court is observing in this case. Now, the court herein is saying that Article 21 is providing you right to speedy trial. Right to speedy trial is implicit in Article 21. This was also something we have been hearing since the case of Husainera Khatun also. But courts must also assess each case individually. So there may be cases which have no possibility of being decided in the time frame, and that does not mean that if they're not decided, the accused should be discharged or he should be acquitted. Okay, so no person should suffer prolonged trial without just cause. But of course, that does not justify a universal time cap over criminal proceedings. Now, acquittal or discharge solely on the grounds of delay defeats the purpose of justice. Courts must also evaluate the reasons of delay and conduct of the parties, prejudice caused, and nature of the offense before awarding any kind of acquittal or discharge or any sentence. Now, of course, there is a delay. Nobody is denying that there is no delay, and accused is also somewhat suffering out of the delay that has been caused in the trial process, or processes that are initiated for criminal investigation or trial. But if an court herein is saying, but if an accused is prejudiced by inordinate delay, there are long gaps of time. Courts, he has alternative remedies available. So there are a benefit of bail, statutory bail. We have a provision. Proceedings can be quashed. Appropriate directions can be passed by the courts, because we do have provisions relating to same. But that again should not be based on the rigid timelines. Okay, so court herein is saying that criminal courts should exercise the power available, such as those under 309, 311, and 258 of the Criminal Procedure Code, to effectuate the right to speedy trial. A watchful and diligent trial can prove to be better protector of such right than any other guideline capping the upper time limit. Okay. Now, in appropriate cases, jurisdiction 482, inherent jurisdiction of the High Court, and writ jurisdiction, or supervisory jurisdiction of the High Court can also be invoked. Okay, but the perception of the cause for delay at the trial and in conclusion of criminal proceeding is necessary so as to appropriate whether setting up bars of limitation entailing termination of trial or proceedings can be justified. We need to achieve the goal of speedy justice, and it can only be achieved by a combined and result oriented collective thinking and action on the part of legislature, judiciary, executive, and of course the members of the bar. Okay, so now High Court, the Supreme Court herein is saying that no such guidelines can be permitted, because number one, judiciary cannot legislate. It cannot prescribe rigid procedural deadlines. This is in the scope of legislative action, and that is impermissible legislation if judiciary does so. So it also clarifies the scope of right to speedy trial, providing that speedy trial is not quantitatively analyzed, that you have to complete a trial in so and so number of months, but rather it is qualitative in nature. Each case demands its own sweet time to be decided. Preventing this case is also signifying the prevention of misuse of procedural timelines to obtain technical acquittals, especially in the serious cases like that of economic offenses, corruption, money laundering, because this case is stemming from a corruption case only, and of course other serious offenses like murder or rape, etc. Now, when we yes, so with this, the Supreme Court, the Supreme Court is overruling the precedents, which were laid down, which the timelines which were fixed in the case of Common Cause versus Union of India 1996 Supreme Court and Rajdev Sharma versus State of Bihar 1998 Supreme Court. It is a landmark decision with respect to the fact that it is harmonizing constitutional rights of speedy trial with imperative of a robust justice delivery, so that no injustice is suffered either by the victim or by the offender or accused out of the delay. Now, delay in trial must be assessed contextually. There is no one size fits all formula, and judiciary must balance the rights of the accused with the interest of society in punishing crime. This was it, which was held in the case of P. Ramchandra Rao versus State of Karnataka. I hope this video was useful for you. Thank you for watching. Please stay tuned with Legal Darshan. For any feedback, information, queries, suggestions, you may write to us at legaldarshan@gmail.com. The email ID is there in the description box below. Thank you, everyone. Thanks. Keep watching. Stay tuned. Have a great